A local authority, Respondent, and JB by his litigation friend, the official solicitor, Appellant.
Welcome to the Supreme Court. Lord Stevens will explain the judgment which we are delivering today.
The Supreme Court hands down judgment this morning in the case of JB by his litigation friend, the official solicitor, Appellant, and a local authority, Respondent. This is a brief summary of the court's reasoning. This appeal raises issues of profound significance under the Mental Capacity Act 2005, the Act, for JB and others like him with an impairment of or a disturbance in the functioning of the mind or brain, which potentially renders them unable to make a decision for themselves in relation to having sexual relations. The central issue is whether the information relevant to JB's decision to have sexual relations, which he must be able to understand and which he must be able to use and weigh, includes the fact that the other person must be able to consent and gives and maintains consent throughout. Proceedings were commenced by the local authority in the Court of Protection, seeking declarations as to JB's capacity, including his capacity to have sexual relations. The issue in relation to having sexual relations, as formulated by the parties, was whether JB, to have capacity to consent to sexual relations, must not only understand that he can give or withhold consent, but must also understand that the other person must be able to consent and gives and maintains consent throughout. At the material time, it was evident that because of an impairment of or a disturbance in the functioning of his mind or brain, JB did not have that understanding in relation to the consent of the other person. The fundamental submission made on behalf of JB was that the consent of others is not relevant to the question of whether he has the capacity to consent to sexual relations. The judge found that relevant information for the purposes of determining if JB had capacity to consent to sexual relations did not include that the other person must be able to consent and gives and maintains consent throughout. The local authority appealed to the Court of Appeal. The Court of Appeal recast the relevant matter for decision as being whether JB had the capacity to engage in, rather than consent to, sexual relations. The Court of Appeal found that in deciding whether a person had capacity to engage in sexual relations, a judge should have regard to whether that person can understand that the other person involved must be able to consent and gives and maintains consent. The local authority's appeal was therefore allowed. JB, by his litigation friend, the official solicitor, appealed to the Supreme Court on 5 grounds. The Supreme Court unanimously dismisses the appeal on all 5 grounds. In respect of ground 1, JB argued that it was wrong to recast the relevant matter for decision under section 2.1 of the Act as being whether JB had capacity to engage in sexual relations, as that would be inconsistent with section 27, which sets out those decisions which cannot be made on behalf of a person, and which refers to consenting to have sexual relations. However, the wording of section 2.1, which is broad and flexible, is not controlled by section 27, and the matter for decision was properly cast as engaging in, rather than consenting to, sexual relations. This ground of appeal fails. In respect of ground 2, JB argued that even if the relevant matter was cast as whether a person had capacity to engage in sexual relations, in answering that question, it was not relevant to look at whether that person understood that the other person must be able to consent and did in fact give and maintain consent throughout the act. JB argued that this interpretation of the act inappropriately extended its purpose to protecting the general public and moreover created an impermissibly person-specific test for capacity. However, the Court for Protection should have regard to reasonably foreseeable adverse consequences with the aim of protecting members of the public as well as persons who may lack capacity. Furthermore, the test in Section 2.1 is decision-specific, not person-specific. This ground of appeal fails. In respect of ground 3, JB argued that to have regard to whether a person had capacity to understand that the other person must be able to consent and must in fact consent before and throughout the sexual relations creates an impermissible difference between the civil and criminal law. However, it is possible for the civil law to impose a different and more demanding test of capacity, and any differences are amply justified by the Court of Protection's responsibility to protect persons who may lack capacity as well as to protect others. Furthermore, any differences between the civil law test and the criminal law test should be assessed as they arise in individual criminal cases. This ground of appeal fails. In respect of ground 4, JB sought to argue that the Act must be construed compatibly with Article 8 of the European Convention on Human Rights, which provides for a right to respect for private and family life. However, this ground was not raised prior to the appeal to the Supreme Court, and permission to raise it is refused. And nevertheless, the Court finds that the operation of the Act is compatible with Article 8. In respect of ground 5, JB argued that the Court of Appeal's test for capacity to engage in sexual relations was inconsistent with Article 12 of the United Nations Convention on the Rights of Persons with Disabilities, which provides for recognition that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. However, as there is no separate standard for persons with disabilities in the area of having sexual relations, this ground of appeal also fails. Furthermore, in SC, CB, and 8 children against the Secretary of State for Work and Pensions, this court has recently confirmed that it would not examine whether the United Kingdom has violated provisions of an international treaty which are unincorporated in domestic law. The Supreme Court accordingly dismisses this appeal.
And as well as dismissing the appeal, the Court has made an order that no one shall publish or reveal the name or address of the appellant, or publish or reveal any information which would lead to the identification of the appellant or a member of his family in connection with these proceedings. The Court is now adjourned